You have a right to remain silent. It's part of every police arrest in the television or in the movies, but it's rarely part of an arrest in the real world. Why not? I'm Northern Virginia criminal defense attorney Scott Nolan, and I'm going to talk to you about your Miranda rights. The Miranda rights, as they've come to be known, come from the Supreme Court case of Miranda versus Arizona, which says 4 things, basically. Number 1, you have a right to remain silent. Number 2, anything you say can and will be used against you in a court of law. Number 3, you have a right to an attorney present when you are questioned. Number 4, if you don't have the money to afford an attorney, the court will appoint one to represent you. So that's something we've all heard since we were little kids, every time we watch a police show. The thing that many people miss is that it only comes into play when the police are going to question you, and only if they question you after they arrest you. This is why most police questioning occurs before you're arrested. Hello, sir, do you know why I've pulled you over? Ma'am, how much have you had to drink? All of those are questions the police can ask without reading you your Miranda rights, because you're not under arrest. So that's the most important thing to know. You have a right to remain silent at all times, but the police only have to tell you that you have that right if they're going to question you and they've arrested you. So exercise that right to remain silent before, during, and after the arrest. Just don't talk. I'm often asked, well, can the police put me in handcuffs and not read me my Miranda rights? And the answer is absolutely. They can put you in cuffs and arrest you and charge you and convict you without ever reading you your Miranda rights. If they don't question you, they're okay. Now, if the police do cuff you and do question you and don't read you your Miranda rights, then the odds are pretty good that the judge is not going to allow anything you told them to come into evidence. Doesn't necessarily mean that your case will be thrown out, but it does mean that your statements can't be used against you. In the original case, Miranda versus Arizona, Miranda had admitted to kidnapping and sexual assault. The police had him sign a piece of paper saying that he knew what his rights were, but they never told him he had a right to remain silent, and they never told him he had a right to an attorney. And the Supreme Court decided that that was unfair, that in order to question somebody after being arrested, you had to inform them of those basic rights, and it's been part of police procedure ever since. So, if you've been arrested and questioned and not read your rights, talk to an attorney. If you've been arrested and not read your rights, but there was no questioning, it's the way it goes. All right, I hope this answers some questions. If you have questions about this or any other legal matters, please feel free to contact me. I'd be happy to talk to you about it. Have a great day.